I really apologize for this failure of the presentation, because I was going to talk about the Russian legislation. I think that you know what I'm going to talk about. My name is Sarkis Darbinyan, and I'm expert of the Pirate Party of Russia. We are a political organization, but and that's why we are so much involved in legislative work. There will be another speaker after me, Artyom Kozlyuk. He is head of Roskomsvoboda, and he will talk about the implementation and the practical aspects of the recently adopted legislation. I will try to discuss the changes that happened to hosting providers in the last couple of years because of the Russian legislators. One of the milestones, one of the more prominent events of the past was amendments to the fourth part of the Civil Code of two articles, provision 1250. This is when you don't need to prove the party guilty if the party is engaged in entrepreneurial activity, and approximately at the same time another article of the Civil Code was amended. I'm talking about Article 1253 Prim. This is an article on information intermediaries, and for the first time in history the legislator ruled who is the hosting provider and internet access provider, and the legislator defined the conditions under which the hosting provider is not responsible for violation of intellectual property rights online. In Article 1253 Prim, there were, from my point of view and from the point of view of other experts, there were a number of dubious propositions that were partly copied from the American Act and partly designed by the Russian legislators. Probably many of you all remember the Перекресток case when the copyright owner sued Перекресток supermarkets, and he proved in the court of arbitration that Перекресток violated copyrights for images, and that image was published in the TV Park magazine originally. So that was the first precedent, and then the question arose whether an intermediary that delivers a certain content should be liable for the legality of this content's placement. So that was the first digital case in the analog world, and then a little bit later this precedent became a law, in particular that article of the Civil Code, and it also became part of the digital practices. This article is currently it is worded in the following fashion: the information intermediary, the host, provides placement of content online and is not liable for violation of intellectual property rights due to placement of certain materials by the third party or under his instructions if the intermediary complies with the following conditions. 1. The information intermediary, the host, did not know and could not know that the use of intellectual property rights are contained in those materials are illegal. He didn't know and he couldn't have known. And secondly, if the copyright owner asks in writing the information intermediary to remove that content, the content is removed. I'm saying that these two conditions are dubious and they are ambiguous because that wording didn't know and couldn't have known. Well, Russian courts are already saying that if the copyright owner place this information somewhere, or if he sends a letter to all hosting sites and website owners saying that he is the owner of the following rights, then this means that the party, the owner of the website or the hosting provider, should have known about the rights of that owner. Unfortunately, in such letters,
the material may be published at different URLs on different websites, And in terms of logic, it's fairly obvious that the intermediary just could not be aware about the actual placement of the illicit or illegal content on their servers. And thirdly, they should have deleted the content from their site upon a written request. But today we don't have any public registry of the copyright, and the intermediary is unable to verify whether that was the request from the real owner of the copyright. But sometimes the copyright owners believe that other users of their intellectual property violates their rights, and we saw that the license holders for distribution of the films on a certain type of media, when they saw their movies on the internet downloaded, they saw this as a violation. I'm talking about video films, and they have different types of rights, and they have to sell their product for a certain sum of money, and they therefore inform all the hosting sites when they see their content there to actually delete this content. There is no chance to actually check and verify whether it's really true, and it proves to be a problem. Yet there is another problem. Today we have severe immunity violations. I'm talking about mailing violations. There is no such definition in the legislation. There has always been a basis for the foundation for communication. I would like to clarify what I mean. The mailer who delivers the correspondence from one point to another is not responsible for the actual content of the mail, of that what the mail contains. They cannot expose it or somehow challenge its legality. But we have seen a new legal trend recently when the hosters, when they perform their mailing function, are deprived of that mailing immunity right. And it again breaks the foundations of the communication space. This trend exists not only in Russia. However, I think Russia sees a lot of growing initiatives trying to regulate the internet environment. And after a law 139 opened the Pandora box of such legislation started springing up at a very high rate. Different websites permissions were issued. Those websites that promote CP, for instance, or arms trade. But today we have gathered in the State Duma approximately 20 draft laws to prevent access to the alcohol promoting websites or alcohol trading website, the sites that promote ads at the daytime, violent attitude to animals, etc. Such drafts will increase, and the hosters play a very difficult role here. They are the actual intermediary between the publisher who publishes any such material and the users and the right holders, the right owners, and the public institutions and the law enforcement agencies that require to delete such illicit material in a very short span of time, in 1 day or 3 days maximum. we cannot avoid such initiatives from springing up, and the hosters are therefore trying to cope with the new environment, the new Russian legislative environment, and the new trends. They try to tune to these trends, but I think it requires to hire a lot more legal experts, because there will be plenty of lawsuits following this trend to cope with. Protecting the owners of websites, I, as a practitioner, very often see that in Moscow city court we don't have the plaintiffs, and it's the hoster which is considered to be a plaintiff. The defendant is considered to be the defendant and would have to pay the tax duty, which is 4,000 rubles, duty for each illicit case of the illicit use of such materials. This is the situation, which is quite obscure, and the hosters would have to take this blow. They are public, they are well known, they host this information. If they are located in the Russian Federation, there are some ways to influence them. This approach, I believe, does not actually welcome the new trends for growing the Russian internet, and it's counterproductive. But that's what we have. One of our targets is to mitigate the negative outcomes which we saw after a number of prohibition legislation was adopted. And we want to take measures to change the adopted legislation and avoid adopting the new set of laws and rules which would allow to block more internet sites. That's all. Thank you very much. Any questions? I'm Gennady Abramov, Zaolin Communications, CIS. I'd like to ask you a question about this content filtering and the blocking of the websites. It is linked to the telematic license, and the telematics is a very vague term. It seems like that the hoster which does not provide the internet connectivity service, formally they would still have to register in the system, download this list of the sites that are prohibited to open, and filter the content. Otherwise, if they don't do so, they will be penalized and fined and punished. As far as I know, there is no way of avoiding it. If you're a telematics provider, even if you don't provide internet connectivity services formally, you have to meet this requirement, otherwise you'll be fined. Exactly. You are quite right. And again, there is another draft law which will soon, I think, will be adopted, and the hostess will be fined up to 1 million rubles for each particular violations, from 300,000 to 1 million rubles, and it will basically bury their business if they once be imposed a fine of such magnitude. Sarkis, thank you very much. I'm here. I'm Yuri Bogdanov. Sarkis, could you please tell us, the hosting providers very often been accused of multiple things. Some people claim, I mean, in written form, that blah, 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 this user is violating these laws, and they, as a hosters, there are always certain numerous requests, anonymous requests, to block this and block that. And the hosters would resend these letters to the client, the customer. Normally the customer would say, these are my copyrights here. That seems like that the hoster has been warned about them violating the rights, and on the other hand they have the owner who claims that they are aware. So what do they do? By law they will have to block the information, otherwise they will end up badly, but in actual fact it looks very strange. Seems like that the hoster will have to judge and define who this copyright actually belongs to and how they exactly they violate. I think it should inform the user very timely and block the information to maintain your business, but still make these abuses public. Instead of the content which is prohibited, you should replace this content with the explanation why that information was removed from the site, and explain the reasons. Okay, when you are located in Russia and you are in the Russian legislative environment and you are a Russian legal entity, you need to meet these requirements. But once we put it in a neighboring state, Ukraine, Europe, elsewhere, we are automatically exempt. It's true, you are automatically exempt. When you belong to the Russian jurisdiction, when you are licensed in Russia, you can, and you must fulfill all the requirements. But when you're outside the Russian Federation jurisdiction, the Russian legal system can no longer do so. But it's, you know, they can, of course, but it will take a long time and it's quite a complicated procedure. As far as our investigation looks even worse, from what I know, the legal norm is going to be enabled. It doesn't really matter where the hoster is located, but where the service is provided. Where this service is provided, that's what is important. And the clients, people checking the website, if they in the Russian Federation physically, then the Russian legal system considers this matter using the Russian legislation. So it's much worse. See? As far as I know, it has not been distributed widely, this norm that I've just explained, but it will. You need to address this. Yes, it's true. It's one of the brave attempts to bring all the internet to the Russian jurisdiction and apply Russian legislation to all of the websites. But if you're outside Russian Federation, you cannot be sanctioned, and they will not be able to ask for the reimbursement, for instance. I think everything is being done today to squeeze out the hosting services from Russia. It seems like that there are enemies in the State Duma members and some of the officials who vote in favor of this stringent approach. There are some other participants here. Let's listen to their questions. I would like to take offense. What about the pipeline? You spoke about the hosters, but what about the pipeline, as we put it? We download all those registries, and we'll have to expand our infrastructure to filter everything, what people download. And I would like to use this opportunity and clarify this mailing neutrality principle that you spoke about, and that was a case in St. Petersburg. Let me read the quote. 149 Federal Law on Information Technology and Information Protection. Part 3, paragraph 17. if this is limited by the federal law, the mailer does not hold responsibility if they don't know that it's unknown, it's illegal. We'll have to download these lists of terrorists and CP and use this and apply this to filter the content. We need to protect the poor users. This neutrality principle that I've just quoted, can it be applied to us, the pipeline? I was missing this. You are being the ISP. We are a mid-size ISP, the provider. Mid-size, as you showed. I didn't speak about internet service providers. We speak mainly about hosting, but we are involved, certainly, and it touches you as well. One of the brave practices done by a few ISPs, and I would recommend you to take as a civil stance and position, is you must block this information by law. If you don't, it will put your business to the end. But put the explanation and put the explanation where you explain the ways to avoid these blocking tools. How you do it? Formally, you block the information formally, but this does not refrain you from explaining how they can get this information in alternative ways. I remember the description from the prosecutor of Makhachkala, where it was required to limit access to a few proxies, anonymous proxies, which was used for that purpose, but they even want to close even the anonymous proxies. That's interesting, that's interesting. We heard about that a long time ago, the FSB initiative, that such anonymizers and proxy servers and VBMs and Tors would have to be prohibited. There's no such law, but we know that the prosecutors don't really care about Article 15.2, 15.3 on federal law and information. They just sue the internet providers and they sue the ISPs and prohibit them to spread this information over the internet. Hide My S at Dagestan example is a notorious example. You see, we are in the avant-garde and we're in the front line. We're in the front line, being attacked. Sarkis, all this blocking relates to the providers. The provider will have to block the information on the territory of the Russian Federation, and the access to the other sites located elsewhere must not be blocked. If I belong here, but it's located elsewhere, I blocked all the Russian networks, and I explain why this site has been blocked. But you just put Opera in the Opera Turbo mode, activate the Opera Turbo mode, and use this. Simple as that. Of course you can do it, but it does not require any manual settings change. There are some manual settings, but you can automate this as well. And also, I want your comment. Some time ago, an ISP was accused of not downloading such lists of the prohibited websites, and they were going to take them to custody, but they didn't. Could you please explain that? Yes, there was such a case, and it was decided that the blocking requirements were not included in the licensing requirements. That means that the provider could not be fined for not blocking this or that information. A very optimistic outcome, and the entire internet community welcomed that decision by court. It was actually the first court that started defending, I mean, not defending, but understood the ISP's position, but seems like pretty soon it's going to be changed, and there will be yet another mandatory rule for all of the ISPs to block this information according to the license requirements and delete it from the registry. I'm Andrei Mikhailov. I have a suggestion, not a question. There may be an initiative created to create a registry of these so-called prohibited, but not prohibited, how to put it, all these resources, the registry of these resources that are copyrighted, which would help all of the hosters to actually learn exactly what is copyrighted and what's not. What you're trying to say really makes sense, and I'm actually in favor of such measures. If we make our copyright legislation more stringent, we just need to create a public registry, a very transparent registry to protect the copyright. The Paris Convention stipulates this procedure and makes it formal. If you would like your right to be protected and observed, go to the Ministry of Culture, pay the tax or duty, be put in the registry, and then any user checks this openly, sees that this is yours, this is copyright protected. That's it. This initiative had been expressed a few times previously, but practically it has not been implemented. The copyright owners wouldn't want to pay money for that. They make it simpler. Call everyone a pirate, block the mass site, and it's a simple solution, a simpler one. One final statement and more positive comment. Sofia Granushkina from NF Expertise. Sarkis, I've been listening to you and seems like it sounds horrible. Everything's so bad in Russia and the IT business should just immediately leave Russia. But let's speak about some good things. What about some good legislative initiatives? Ladies and gentlemen, let's not start on because I know something about the good initiatives. Sofia, it's excellent, but please take this on the sidelines, make it a sideline discussion, because we are even shifting our coffee break, but there will be a coffee break where you can actually discuss all the positive things, and all the things who think that everything is bad go to Sarkis, and all the people who think that everything's good go to Sofia. And